Signature towing, item number 11. Chris? And I think Representative Signature Towing is here, are you not? Okay.
Good morning, Chairman Denton and Commissioners. I'm Chris Prentice from the Enforcement Division representing the department in this case. On July 20th, 2011, a hearing was held at SOA. The hearing concerned alleged violations from 4 different cases. Originally, there were 6 alleged violations. However, we withdrew 2 violations during the hearing. The ALJ found and concluded that the department proved the remaining 4 violations. Our discussion today concerns the proposed penalties from the ALJ. Number 1, on November 19th, 2009, respondent performed a private property non-consent tow from an apartment complex in Plano. The vehicle was towed because its inspection sticker was expired. Law does allow vehicles to be towed for expired inspection stickers, but only if the owner or operator of the vehicle is given at least 10 days' notice, either in person or by certified mail return receipt requested. Respondent placed a large sticker on the driver's side window attempting to give notice. Although the ALJ was sympathetic to the respondent's attempted notice, the ALJ found that this did not comply with the statutory requirements. However, the ALJ recommended a penalty of a reprimand because this violation is not listed in the enforcement plan. The department argues that this was a tow performed without authorization and should be considered as a Class C violation, as are other unauthorized tows, such as those under Section 2308.255. The range of penalty for a Class C violation is from $1,000 to $5,000 and or a 1-year probated suspension up to revocation. The department requests a penalty of $3,000 due to the seriousness of this violation. Number 2, additionally, the same vehicle towed on November 19th, 2009, the invoice provided to the vehicle owner failed to include the contact information for the Justice of the Peace with jurisdiction over hearings to challenge tows. This is a Class B violation. Evidence proved that the respondent only posted the Justice Court information at the VSF and did not routinely provide that information to persons claiming stored vehicles. The range of penalty for a Class B violation is from $500 to $3,000. The department requested a $1,000 penalty. The ALJ suggested a penalty of $500, the minimum penalty. Number 3, respondent performed a non-consent tow on January 2nd, 2010 at the request of the Allen Police Department. Respondent charged a non-consent tow fee in an amount that exceeded its fees on file with the department. Specifically, respondent charged $45 for a dollies or carrier charge instead of $35. This overcharge is a Class B violation. The department requested a $1,000 penalty for this violation. The ALJ recommends a penalty of $500, to which we're not objecting. Number 4, another violation with respect to this tow on January 2nd, 2010 was that the invoice provided to the vehicle owner failed to include the respondent's complete certificate of registration number. The invoice is printed and used by the respondent left off the first 2 numbers, both zeros, so it was not a complete registration number. The ALJ recommended a penalty of $350, and the department concurs with that penalty. On September 19th, 2011, the ALJ issued its PFD and made the findings of a penalty of a reprimand plus $1,350 of administrative penalties. The department requests a penalty of $4,850 as described above, and a modification of the findings of fact and conclusions of law to reflect the higher penalty. I'll now take any questions.
Any questions of Chris before we hear from the respondent? Thank you, Chris.
Thank you.
Good morning.
Good morning, Chairman, Commissioners. I'm J. Pete Laney. I'm here on behalf of Signature Towing, along with Lance LaBarba, who is a representative of Signature Towing. I did not participate in the underlying hearing. I have gone back and read through all the pleadings, looked at the exhibits, as well as listened to the audio of the hearing, and I'm sure my good friend, Mr. Prentice, will keep me on task here, as well as Mr. Bowman. I guess we're okay with the PFD in some respects. Some of the stuff I heard today was a little different than we expected in terms of agreeing with the judge's decision on some of the penalties, but I'm going to address the first two smaller penalties first, and then talk about, I think, which is the bigger issue, which, as I've been studying this issue and talking to folks around the state, it's a very big issue because it's happening everywhere. The no notice of the justice of the peace, there was the testimony at the hearing was, at this time in 2009, Signature Towing had the documents, the information sitting on the counter and they would tell the customers that came to pick up their vehicle to take one of these. It was admitted at trial that there was no proof that the person actually took one, but it was their customary, unrefuted testimony was their customary business practice to have that sitting there. Since that time, it is now copied on the back of the invoice. So when they sign the invoice, they know that the rights are copied onto the back of the invoice. So in that instance, I believe that was a $500 fine that the judge recommended. You know, again, we don't have any proof that the person actually got it, so that is a mistake on Signature's part. We just think that penalty, in the discretion of the commission, could be reduced. The two zeros left off of the invoice that Mr. Prentice referenced, in our opinion, that was purely a typographical error or a mistake on behalf of printing the invoices. They print invoices 20, 30,000 at a time. Noticed the mistake, didn't notice the mistake, and it popped up in this case. It has since been fixed. In our opinion, that's an administrative act, a ministerial mistake, shouldn't warrant a fine, but of course that's certainly up to the discretion of the agency. It was not intentional, and I don't think it harmed the public in any way, in the sense that there was nothing else on there where they couldn't. The rest of the number was actually complete. I think the judge in her PFD at one point wrote down the wrong number when she was describing this, but later on in her analysis she typed that she got the right numbers. So the number was there, it was just missing the preceding two zeros. The $45 versus the $35 charged in the case in the terms of the dolly or carriers. The Signature Towing has several municipalities up there they represent: Allen, Plano, Richardson, and Mr. Moses, I hope you haven't had a run-in with them. But for example, Richardson charges $45. They charge $45 for this service. You know, it's not. They can charge whatever they want as long as it's posted on their schedule. It was posted. Richardson. This was a Richardson driver that was covering a shift in Allen. He wrote down the wrong number. They found out. The complainant didn't complain to them and offer a refund. The complainant complained to TDLR first. And so thus this alleged violation. Now the practice is they have checks and balances that when it comes in, they make sure that it corresponds with their tow rate, and they issue immediately to the addressee on the refund by check, so they'll have proof that it was done. The big issue and the $3,000 fine that Mr. Prentice referred to, Signature, like a lot of towing companies, offer services to apartment complexes and have contracts with apartment complexes. Particularly in the areas that they work, North Dallas area, apartment complexes are being fined heavily by municipalities for having abandoned vehicles, by the police departments going on there and fining them for violating city ordinances. What Signature does is in conjunction with the apartment complex, is they'll go through and have a list of violations that they'll look for cars that, abandoned cars, flat tires, written out in their contract with the apartment complex, as well as the lease between the apartment, between the renter and the apartment management company. One of the things is an expired inspection sticker. That's just one of the things that it can be towed for. In order to try to provide notice to the residents or the owner operator of the car, what Signature has done, as well as other tow companies around the state, is post a big sticker, and it's in the record, a 4x6 sticker onto the window, and it has checked, what the violation is. They turn that information over to they write down the VIN number, or the information from the car, where the violation is, where the car is, provide that information to the property management company, to the apartment complex. They then take that information within a certain amount of time. In this case, it was 12 days, more than the required 10 days. 12 days, the apartment complex notifies the towing company, this car's still here, it's been posted, come pick it up. The staff has taken the position that does not comply with the statute, that the statute says you have to give in-person notice or by certified mail. There was argument made at the hearing that, by Mr. Prentice, certified mail, they wouldn't see the sticker if they were on vacation. Well, they wouldn't get certified mail if they're on vacation either. And the statutes don't require that certified mail be seen. It just requires that it be sent, and then 10 days lapse. So this was the best way that Signature knew how to, try to provide a notice. It's worked great. I mean, there's instances where there's been some complaints, but for the most part, people respond to it. The apartment complexes really appreciate it, and it keeps them from getting in trouble with the city. So I think if you went back and listened to the audio of the hearing or looked at the record some, I think the judge struggled with this a little bit in trying to decide what to do, and that's relevant. I think that's evident in her sanction hearing, her ruling on what the sanction should be. I would agree with her on that instance where the violation of this statute does not appear in the penalty provision of the schedule of penalties, therefore not providing the licensee with notice of what the penalty violation would be. But I also think that this is a big issue that's going to have to be resolved, and whether or not this is this notice, because I know what's being done around the state. I know there's a case that we have that will come up subsequent to this one, not today, but with the same issue. And so the question will be whether or not the notice provided under the sticker is good enough. And
versus a certified mail.
Right. We would argue that this was the best we could get in-person notification. And here's the reason. A towing company does not know who owns the vehicle. They cannot run the DMV. It's against the law for them to run the DMV until they have towed the vehicle. So what they do is to get the information and provide it to the apartment complex, who may or may not have that information because it may not be a tenant, or maybe a visitor, maybe a borrowed car. They don't know who the owner or operator is. So towing companies are stuck in a situation where they can't go run the DMV and send a certified letter because it's against the law to run the DMV till you've towed that vehicle. And so this is the best way that Signature and presumably the other companies around the state that are doing it have figured out how to do this to provide notice. Once they tow the vehicle, then they can run the DMV and send the required notice.
Have you taken a look at our rules?
Yes.
And what did our rules say?
The rules
what notice requirement is it in our rules?
It says in person or by certified mail return receipt requested. And so
I thought there was too.
And so I guess it's an interpretation of what in person means. I don't know, and this this may be something that needs to be taken up to get a decision on, but I know it's going to be an issue, and they certainly are not trying to, they're trying to do everything above board, and I certainly don't think warrant a $3,000 penalty. I think the ALJ, if it is a violation, I think the ALJ was more in line with what it should be. Consider the steps that they took to try to comply, given the catch-22 that they're in. And Mr. LaBarba's here if you have any questions.
I'm interested in what we heard from the department, what they felt was an appropriate penalty. What do you feel is an appropriate penalty?
For which?
Any and all.
Well, I would argue that because of all of them are Class A, except, I believe, for one, except for the $3,000 one, that just reprimands would be appropriate based on the actions that, based on the circumstances. I think what you have to consider, the factors to consider on the sanctions are the seriousness of the violations, the history of past violations, which these were all alleged as first violations, the amount necessary to deter future violations, and the efforts made to correct the violations in any matter justice may require. Every violation in here, with the exception of the sticker, because we just don't know the answer to that question, has been resolved. Yes, there's going to be, everyone's going to make mistakes on overcharges, but they figured out a way to ensure that that money's refunded as quickly as possible. And so I think the seriousness, I don't believe is here. The history of the past violations, none. The amount necessary to deter future violations. I mean, I think in the exceptions, there was a statement by the attorney asking to send a clear message that, you don't overcharge for $10. I mean, again, people make mistakes, and then they've done what they can to try to make sure that that doesn't happen and to refund the money. So, I mean, my client fully admits that they overcharged on the $10 and that there's no proof that they provided back in 2009 the notice. So, I mean, if deemed appropriate that there is some type of penalty, I just think it's more in line with what the ALJ recommended or less, as opposed to the $1,000 and $3,000 that recommended by the staff.
Any questions?
I've got one question.
Sure, go ahead.
Let me get back to it. On the invoices, it said that, and this may be just on our document that it's wrong. It said the ticket should have listed 00262s, whatever, and then it said, but it listed 5626.
That's an error. That's an error in the ALJ.
Okay, that's what you were referring to.
Right, if you
okay.
turn back farther, I think in her finding in fact, or maybe
Okay,
conclusion.
that's where she wrote, okay.
She wrote it correctly. I noticed that too and went back and looked at the exhibits and made sure that it was right. It's just it's just the zeros that were missing.
Okay, well, I thought that's what you were referring to.
And actually, they went back and had a whole stack of documents, and they had their employees go back and fill in by hand the 00 on the remaining documents now.
Okay.
Because it was a stack of 30,000.
Can I revisit your contention that the relevant to the not being able to, obviously they could present something in person if they knew who that person was.
Correct.
But you're indicating that by law they cannot do that.
The tow company, the way they would determine who owned that vehicle, in terms of the tow company, would be to run the DMV on the vehicle through DPS. They're precluded from law to do that unless they have towed the vehicle. So they can't walk up to the vehicle, look at the license plate, and see who owns it, and then go knock on the door or send them a letter, because the law prohibits them from obtaining that information without first towing. You can't get that information, but there's exceptions, and one of them being the vehicle has been towed.
And Mr. Laney, is that part of the record of whether the law allows the tow company to do that? Is that something
Yes,
that's
I
on
think
the record?
Mr. Cron, who's the general manager, testified to that point.
Any other questions?
I guess the question, when you go to the apartment complexes and find people that are in violations, a list of those people who violated cars are provided to the apartment owner, apartment manager, for them to follow.
They are, and in the record, I don't know if you'll have the exhibits, they're provided with a carbon copy of the sticker. They also take photos of the sticker, and so they'll have that information, so it's good. It's provided to the apartment complex, and then if it's not remedied in the apartment complex, sees the car still there after 10 days, In this case, it was 12 days, then they notify Signature or whoever the company is to come pick it up.
Any other questions? Did you have any further statement that you'd like to make? No, sir. Are there any questions of the respondent? So thank you very much.
Yes, sir.
Mr. Chairman, could I respond to Mr. Chairman quickly?
Sure.
The issue about the not being able to give notice, with respect to this first violation, and I believe, and it came out in the hearing that it is, it was the public policy of the legislature that it shouldn't be easy to tow somebody's car just because their inspection sticker's expired. And it's my understanding, if you want background, I may have to go outside the record just to show why that's not in the enforcement plan, because I didn't know until last week why it's not in the enforcement plan. But I do know if you want that information, I can provide that to you.
What do you mean it's outside the enforcement?
Okay,
plan?
it is not, because this towing vehicles out of apartment complexes for expired inspection stickers or expired registration is under 2308-253, which is directed at apartment complexes. And so what has happened is towing companies have made agreements with apartment complexes to do this for them. And the apartment complex is under the duty that you can't tow those vehicles out of your lot unless you've given these people in-person notice or certified mail notice. Now, obviously, if the tow company can't find out who the vehicle belongs to, the apartment complex certainly can, and they've got 10 days to do it. And so they're not doing it. They've contracted that away to the towing company, let the towing company do all the work, but the towing company cannot comply. And they do not comply, and this is a violation. They're towing vehicles out of apartment complexes just because their inspection sticker might have expired last month. And just because they give them 10 days and say, well, you didn't move it, so off it goes. So that is why it needs to stop, and that's why we've requested a $3,000 penalty. That's also the standard penalty that we request on a first-time Class C violation, because all other unauthorized tows that we penalize for are Class C violations. That's why we've put it at that same level, because it is an unauthorized tow, because in-person notice or certified mail notice, neither one were provided, and that was admitted at the hearing.
Chris, let me ask you a question from a practical standpoint, and I guess it's more informational than it is. Since it's germane to this, and maybe I should discuss it at the time we get into our compliance report, but how do you address a vehicle that's parked there and there's no record by the apartment manager of who it belongs to? How is notice properly given them?
Well, if the apartment has no notice, the apartment can find out. I mean, most of these apartments now require, in a lot of cases, people have to have permits to park their vehicles there.
Let's say it has a permit, and I didn't give them a correct license plate numbers, and they can't identify it. What do you do then as far as notice?
Well, if it's got a permit, the apartment complex is the one that knows who has each permit, and they can go to their resident and say, okay, what's the deal with the car? And if you don't either bring it up to speed, in other words, get it inspected or get the registration renewed, then we're going to haul it off. Because the apartment complex is the one that's in the position to know why each vehicle is in that lot. And these aren't unauthorized cars. These are cars that are authorized to be parked there. They're just cars that happen to let their inspection sticker go out or their registration expire.
What if it was a visitor?
If it's a visitor, then they still, most lots anymore require them to get a visitor pass, and they can still, they can look at the, visitors have limited authorization there as well. So
They get visitors pass because they'll get towed off if they don't.
There was a statement brought up concerning a person who might be on vacation, say a 2-week vacation or whatever. And maybe a notice was put up, certified mail was sent, no response, towed the vehicle.
If notice was sent certified mail and the notice was 10 days prior to the day of the tow, it's lawful, because under the rules,
Certified mail sent by whom?
it doesn't matter, it doesn't say who it's
It
sent
has to
by.
be, basically, it has to be the apartment.
It would have to come from the apartment complex. It's where it should come from. And if they're providing the information to the apartment complex, that's something the apartment complex should do and they could still do what they're doing as long as they get note back from the apartment complex, yeah, we notified this person in person, or we notified this one by certified mail. If you don't pick up your certified mail, that doesn't mean it didn't happen.
Chris,
That just means you weren't
Let me
responsible.
interrupt you here, and correct me if I'm wrong, but I think the bottom line is the department is taking the position that the notice on the window is not appropriate notice.
That's correct, and the ALJ agreed with that.
I understand. And I think to go beyond, and of course, the respondent believes that it is proper notice, and it's the certified mail requirement might be impossible to do or improbable to do. But the problem is the rule that we have today. And I think the discussion we're having is more appropriately to address the rule, to clarify the rule, or to change the rule rather than try to change it through interpretation. I think the rule is what it is.
Mr. Chairman, I was just informed, this is Brad Bowman, General Counsel, that this language is actually in the statute concerning.
Oh, it is a statute.
Yes, it's the statute, it's not the rule. It's 2308, 253E, and it's
So
very
even if we
specifically laid
disagree
out
with
there.
it, the commission has no authority in which to change it.
That would need to be addressed at the next legislative session, I would think. But that's the way, it's specifically stated in the statute. So it's not a matter of one of our rules.
Okay. Any other questions? I know you want to speak. I would appreciate if you're not editorialize about the appropriateness of the rule, but I'll let him speak to it. If you'd like to, you're welcome to.
Only to just, the issue is raised about getting visitor passes and stuff. I can,
You know what? Let's talk about this case, though, and it was inappropriate of me to even ask
Okay.
a hypothetical like that, and it's really more appropriate to talk during a rule discussion rather than this particular case.
then I will, I guess, disagree with a little bit what you said about the statute, because I think you are vested with the authority to interpret the statute.
Do you think we can change the
I
statute?
don't think you can change the statute. I think you could interpret it, and a court's going to give, there's a long line of cases that says a court gives deference to your statute, your interpretation of your statute, and if the agency feels that this is because of the situation this is, that posting the notice with the sticker on there, that complies with in-person notice or however you want to do it, I think you certainly have the authority to do that. Or you'll be given deference to your determination.
I appreciate your opinion.
Chairman Denton, I'd just like to say one thing. It seems to me that the towing company is taking on something contractually that they can't do. The apartment complex is giving them that contract, and so therefore, I just want to make that statement. It just seems as if the towing company is taking on something that it actually contractually can't do.
All these are great statements and great discussions, but I think we're going to have to get back to this case and move forward on it. So does anyone have any other questions specifically relating to this case or the amounts of the penalties? Okay, thank you. Commissioners, the department is seeking an $8,500 penalty. As I understand it, you've now reduced that to how much? $48.50.
Or 43, no? 48.
The PFD
No,
recommends.
43.50, I'm sorry, doing that now.
Make your mind up.
43.50.
Okay, the PFD has in here $13.50. I guess the PFD would add.
It does.
It does?
That's correct. 13. The administrative law judge has recommended a penalty of $1,350 based upon the allegations that they found merit to.
They found out that merit too, right? I think when you have the, and some of these are, first-time offenses and different classes, the Class Bs, especially the one where the charge was the difference seemed like that they should have, whereas they could charge, the company is representing Morgan City is in charging 45 versus 35. I think, you make administrative error, and I think also the other one that the left off of the zeros are more of, more practice or administrative type issues. And and then this other invoice where the owner left, let me see. I don't know. I think that, I certainly think that the 43, I think that's way out of line. I think those penalties are beyond what we should be trying to assess on something like this.
Are Commissioner Moses, are you generally in agreement with the administrative law judge's recommended penalty?
I guess I'm, generally in agreement with that, what has been recommended by the administrative law judge.
Well, I think the ALJ basically agreed that there was some violation that took place. And Commissioner Moses, I would, if you would entertain, propose a penalty of $1,500 for the unauthorized tow, $500 for failure to provide the JP information, and stick with the $350, which would put a fine of about $2,350, and just modifying the P&D to reflect those fine amounts.
I'd second that.
Is that a motion, Commissioner?
That'd be a
Harris
motion,
Mendez?
yes, sir.
The only, I guess, the question where I have with the penalty where the unauthorized tow is, I think that might be some, I think there's some responsibility for the department owner, and I think if the tow justice tried to comply by putting a notice in the car. I know that it happens in our facility, people parking out lot, trying to put notices on them. I think that's, whether that's personal, it says in person, whether the person saw it or not, whether that could be interpreted. I think that violation is, since there's so many questions are surrounded that in terms of whether the responsibility